At this time, I'd like to introduce a scholar and a gentleman who I certainly have a great deal of respect for. We're going to discuss emergency detentions involving individuals with mental health conditions, and IDD are a critical concern in the justice system. Balancing the rights and well-being of these individuals in crisis while ensuring public safety poses many complex dilemmas. In this session, Professor Shannon will dive into these issues, such as timely assessments, appropriate treatment, legal frameworks, community integration to assess the pressing need for strategies to navigate the emergency detentions. Professor Shannon is a Horn Distinguished Professor at Texas Tech University School of Law and a JCMH Commissioner. And at this time, if you'll please join me in welcoming Professor Brian Shannon.
Thank you, Judge Carr. Thank you, Justice Huddle. So I was a little startled yesterday when Judge Turner, who's an SMU law grad, asked for a show of hands of UT law grads. And I was felt a little sheepish putting my hand up because for over 3 decades I've been at Texas Tech. So we need some turnabout's fair play. Where are my Red Raiders in the house? Yeah, all right. Tip, if you ever get on an airplane and somebody says, "Oh, Texas Tech," don't say "guns up." They get a little worried. So this morning I'm going to talk about some various issues relating to emergency detentions, Chapter 573, and some opportunities to consider perhaps some different approaches. I must confess, I did not pick the title. Christy and her team did. If you walk away thinking, well, Shannon didn't solve anything, you may be right. But we're going to try and look at ways to go here. So my goal, and I spent 4 years in the Air Force, and you know the old type of military presentation, tell them what you're going to tell them, tell them again. Well, here's tell them what you're going to tell them. I hope this morning to do a quick review of current emergency detention law, amplify what we heard from the 2 judges at 4 o'clock yesterday about what's new in 23, some county responsibilities, and then I want to spend some time talking about some model law recommendations that we have an opportunity in Texas to consider. So you're familiar with emergency detentions, both warrantless and pursuant to a magistrate's warrant. And just to see another show of hands and make sure folks are awake, how many of you have applied for or signed off or executed a magistrate's warrant? Quite a few. How many of you are peace officers who have participated in a warrantless apprehension? Again, quite a few, though not as many. Well, a few of you have attended some of my trainings before and know I like to use, I guess as a law professor, a hypothetical, but let me set the stage. Let's think about Ann, and Ann's not doing very well. She's in a convenience store late at night. She's disheveled, poor hygiene, wandering up and down the aisles, muttering to herself, snapping at other people who are there, pulling some things off the shelves. The clerk, the 22-year-old clerk who knows nothing about mental illness, tells her, what are you doing? And doesn't get an answer that makes any sense. Tells her she really needs to leave, that she's disturbing other patrons there at the convenience store. She doesn't leave. She continues in this strange fashion that the clerk doesn't understand. Well, the clerk's going to do what? And call the police, of course, and call the police. And really, until the last 15 or 20 years, where was Ann headed? Going to jail. In many of our communities today, Ann's still going to jail. Happily, we've seen significant changes over time. The Emergency Detention Authority has been present in Texas and other states for decades, but we're seeing it utilized much greater. And I could go on with Ann. Let's suppose that Ann, when told to leave, grabs a six-pack, and certain parts of the state, I guess it'd be a six-pack of Dr. Pepper, but nonetheless, runs out the door with the six-pack saying something about Satan's in the parking lot, and Satan's thirsty, got to take it there. So we've now added a theft charge on top of trespassing, loitering, or as Ann bolts through the door, the clerk tries to stop her, and she pushes through and the clerk falls down. Oh no, we've got an assault charge. Or let's suppose instead of a 21-year-old, 22-year-old clerk, we've got a 66-year-old clerk who gets pushed down. Felony assault on the elderly. Officer shows up and tries to run off. The charges can keep building. Or Ann pulls out a 12-inch Bowie knife. Then we're looking at some other kinds of concerns. In any of those, we know that the law officer has the ability to exercise discretion, saying this really looks like a mental health problem. And that's what, through training, CIT, we know about. But let's suppose that Ann wasn't at the convenience store, she was at home. She was a 22-year-old who's come back from college where she's dropped out. She's not able to continue with school. She's in bad shape, not doing well. Her family, not knowing much about mental illness, has tried to persuade her to get help. But as we heard from Dr. Amador yesterday, he said, nothing wrong with me. I don't need help. You need help. At that point, Ann's parents, if they have somebody caring who can point them in the right direction, can go file for a magistrate's warrant and file an application for court-ordered mental health services. And these are often the entrees. But we've had gaps. We've seen exceptional changes over time. The traditional response has been through law enforcement, but not necessarily magistrate's warrant. Keep in mind, really, it's pretty simple under the code. What we're talking about is we want Ann seen by a professional. We want Ann seen by a physician, and by law, Ann has to be seen within 12 hours. We've got a 48-hour cap, at least under current law, as long as it's not a weekend. What if this happened in the convenience store last night, Wednesday night? Is it 48 hours? That's going to be till Monday. Or if it's a 3-day weekend, could be longer. I would submit that Ann arguably would be better off if this happens on a Wednesday night as opposed to a Monday night, because there's a greater opportunity for treatment intervention when the clock is running. So as we know, traditionally, law enforcement, first responders, how many folks in the room are involved with MCOT programs today? A few. So today we see that the first responders may well be a mobile crisis outreach team. These are just a couple of, I'm not as adept as the judges yesterday afternoon to have cat pictures, but I did find a couple of pictures of MCOT teams. The one on the left is from Travis County, and we're in Galveston. So the one on the right is from the new program here in Galveston. And so those response units sometimes are structured to have ride-along where there's a law enforcement officer that's part of the team. Other communities, that's not the case. But people trained in mental health are coming to the scene in many of our communities. What's the discretion when a law enforcement officer gets there? We know that under Chapter 573, that law enforcement officer, if there's probable cause to believe a crime has been committed, can take that individual to jail. All too often in our history, not just in Texas, but nationwide, that was the default. Let's take them to jail. They'll sort it out there. I'm not a mental health officer. We've seen that transition, and under Chapter 573, with the ability to emphasize diversion where possible, even if there's probable cause where an arrest could be made, the apprehended person can be taken to a mental health facility instead of jail. The law standards are familiar to you. A perception, a belief the person has a mental illness, substantial risk of serious harm to the person or others unless immediately restrained. The peace officer can make that decision based on his or her own observations or representations from a credible person. In my hypothetical, who's likely going to be that credible person? The clerk at the convenience store or another patron there at the convenience store. Well, let's double down and look at this language, substantial risk of serious harm to the person or others. In some communities where there's been greater reluctance to utilize the authority under emergency detentions for warrantless apprehensions, I think this language gets focused on too much, in a sense that we don't then turn to the other aspect of the statute that further defines that. And so it's been framed in this narrow, gosh, they must be to the point of suicide or actually physically assaulting somebody else. That's the only time we can act. But we know that statute goes further and includes that second bullet there, evidence of severe emotional distress and deterioration in the person's condition to the extent that the person cannot remain at liberty, or at least to the point for purpose of the statute to be taken to the mental health facility for the assessment at that facility. That's much broader, and it's a probable cause standard too for the officer. I often get asked though by officers, gosh, if I guess wrong and maybe the person really didn't need to end up at the facility, am I going to get sued? Could I be liable? Now, cynically, those are your lawyers in the House say, well, yeah, any of us can get sued at any time over anything. But the likelihood of liability is very small. We know that under the Health and Safety Code in Chapter 571, there is a provision to limit liability of those involved in this process. A person who participates in the apprehension, well, that's going to be the law enforcement officer. The transportation, the detention, the law enforcement officer, the peace officer. If they're acting in good faith, reasonably, and without negligence, they're not going to be criminally or civilly liable for their actions. And that modifies what's in 573. If there's a determination that there's probable cause that this person, that Ann, needs to be taken to a mental health facility, and the mental health facility ends up deciding, no, Ann doesn't really need to be here, and discharges her without admitting her within that initial window, there's very limited liability risk. On the flip side, if the officer doesn't act, and let's suppose that Ann harms herself or others, there could be exposure and liability to potentially to the police department, perhaps for not acting when there was inability to do so, although there's not much case law on that. We also know that with a magistrate's warrant, the magistrate, often a JP, but not necessarily, there's a couple of recorded cases where a member of the Supreme Court, I remember years ago, Justice Hightower, when he was on the Texas Supreme Court, signed a magistrate's warrant. But the magistrate, the county, constitutional county judge, JP, as we know, can sign that if there's reasonable cause to believe that Ann, for example, has mental illness, risk of serious harm to self, or evidences this severe emotional distress and deterioration. Well, let me highlight what we heard yesterday from the judges talking about the legislative session. And I want to piece a couple together, a couple of bills, provisions that relate to Chapter 573 with respect to magistrates' warrants, EDs. The former language, where I've highlighted the word shall there, the former language said may. Now it says shall. So the court that's hearing these EDs via a warrant, when an application is filed, they've got to now permit email PDF applications. not just by physicians. And in the past, prior to September 1, the only individual, you remember with 573, any adult can file an application, but only physicians could file an application via email as a PDF. And courts could consider those or not. Now it says shall, and now in addition to physicians, it's also local mental health authorities, licensed mental health professionals. So it's a broader array. The second bullet there is pulled from one of these bills as well, and this is a bill that the Hospital Association pushed largely at the behest, as I understand it, of Parkland in Dallas. Again, dealing with the thorny problem of an individual who may present in an emergency room initially as a voluntary patient, and then decides they don't want to be there anymore. You'll recall several sessions ago, legislation was enacted that would permit a 4-hour hold to allow for going and seeking a warrant and emergency detention, and the governor vetoed that bill. This is a different approach, I think, to largely the same problem. Now, a physician from that facility can email over the application for mental health services, seek the ED warrant from the court. The court has to receive those now. And then if the warrant is signed and emailed back, the facility can, in effect, hold that person and perform the preliminary exam that's specified in Chapter 573. Now, some of you are law enforcement or judges are thinking, warrant, doesn't a warrant normally need to be served? And when a magistrate's warrant is normally signed in paper, then somebody from the sheriff's office is going to go serve that warrant. Often a trained mental health deputy is going to serve that warrant. Well, here it's being beamed back through the ether by email and a PDF, and the statute says, that's enough to hold the person. So it will be interesting to see if there are any challenges that might come forward as to whether or not the intent here was for this to be self-executing or not. And the legislation's a little unclear. Also new in 23 that you heard a little bit about yesterday, but I want to expand upon, is one of the provisions that JCMH recommended, Judge Carr's committee recommended, is that we want our peace officers to be able to get back out on the streets. And so now, with this change to 573.012, a law enforcement officer who is, say, the mental health deputy who's served a warrant and escorts the person to the facility is going to sign the paperwork, do the handshake and the handoff, and they can leave. And they can go about their way and get back out and doing their law enforcement duties. They cannot or should not be told, no, you got to stay while we do medical clearance. I think this is a great change. What's disappointing to me is it's half a loaf. It doesn't extend to warrantless EDs. And I'd like to see us try again in the next session to pursue that with the same idea in mind, that we want to have our peace officers have the ability to, when they've exercised their authority to transport the person to the mental health facility, that they're not told, you got to stay there 2-3 hours while we do various medical clearances. So perhaps more to come on that. We know that in some counties, particularly more remote rural counties, there's still perhaps law enforcement reluctance or lack of awareness of some of the authority under Chapter 573. Sometimes it may be judicial reluctance. Sometimes it may be with respect to, is there a facility that's been designated for persons to be transported? JCMH last March held an emergency detention roundtable to flesh out and talk through a number of these issues and look at potential solutions. If you've not seen the report, I've put a link up there. It's somewhat small, but you're going to have access to these slides after the show, or just go to the JCMH website, and under reports, this report is there. And it's got a lot of helpful information with respect to some ideas, some approaches that could be taken to broaden the utilization of emergency detentions. Because don't we want Ann to be seen by an expert, a professional, to try and open the door to the potential for mental health treatment? Now, with some of the rest of my time, I want to talk some about the work of the National Center for State Courts. That body, in conjunction with the 50 chief justices from around the country and the state court coordinators from around the country, they formed this group in 2019, 2020 to look to the state courts to try and lead change with respect to approaching mental health issues. One of their regional meetings, one of their regional summits, JCMH hosted here in Texas, in Austin. Chief Justice Hecht was instrumental in bringing that group here, but they held these around the country. So they engaged in a lot of activities. One of those activities was the appointment of a model code work group. And some of you attended the summit last year at the now I'm forgetting, the Big Bad Wolf, the Wolf Lodge last year in Grapevine. Yeah, I got it wrong. Isn't this a great place? Judge Mack from Michigan was one of the speakers. He was both on the National Center for State Courts Mental Health Task Force as well as on the Model Code Work Group. And the Mental Health Code Work Group was co-chaired by Ron Honberg, the former general counsel and vice president for policy development at NAMI National, and the gentleman I have pictured there, Judge Steve Leifman from Miami. One of the nation's leaders in trying to approach issues involving the intersection of mental health and criminal justice issues around the country. He's been very generous with his time in trying to take what they've called the Miami model and extend it to other parts of the country. In fact, there he is when he received the William Rehnquist Award for his outstanding work as a state judge. Well, that group partnered with the Equitas Project, which was a project that was staffed by Mental Health Colorado to assemble this model code work group. And I had the opportunity to be one of the lawyer/law professor representatives on this body. It included not just lawyers and mental health policy folks, but also a number of psychiatrists and psychiatric professors at various top medical schools. Well, when I got asked to serve on this, I thought, well, Equitas Project, what's that? I'd never heard of that. And of course, as we do, I Googled and learned that it's a project set up by the David and Laura Marriage Foundation, looking at trying to disentangle criminal justice and mental health issues where possible. And then that made me wonder, who were David and Laura Marriage? I didn't know anything about them, but further research revealed that they apparently made a lot of money selling Hot Pockets. They invented, I guess, the Hot Pocket. It's like $1 billion industry. Well, wonderful. So thanks to Hot Pockets, we engaged in this project. We started out in the late fall of 2019, had our first meeting in Denver in November, our second meeting in Miami, hosted by Judge Leifman, the very first week of March of 2020. And what happened that next couple of weeks? As we know, the world largely shut down. That slowed our work. But in 2022, we completed our report, where we identified a number of recommendations for model legislative changes in these 4 areas: guidance for emergency psychiatric interventions, looking at civil commitment standards with respect to court-ordered mental health treatment, looking at medication over objection, and trying to re-envision some of the pathways to care in criminal justice matters. A lot of the things we've been looking at in Texas. And I've got a link to our final report there. Since my topic this morning, though, is emergency detentions, I want to talk about a few of the provisions in the model language that relate to emergency interventions and emergency detention, and whether in Texas we ought to consider some of the provisions that are included. I'll add that this project, the results, the report was endorsed by the National Center for State Courts, endorsed by the Mental Health Task Force, and states are urged to take a look at it. I know the Arizona Supreme Court has already decreed that they're to do a review and evaluation of the various provisions. And I think within JCMH, we can certainly try and look at various pieces. Well, that works. So, a couple of highlights from the provision. One, there's a broad definition of legally empowered persons. Broad definition of legally empowered person. And my little gizmo here is supposed to have a pointer, but they were telling me if I use the pointer and say, see this, you folks online can't see it. So imagine I'm pointing with my big nose towards certain parts. So legally empowered persons. Some of these, think about our own statute, are embedded in Chapter 573. Judges and magistrates, like identified there in 3. Law enforcement, such as peace officers who can do a emergency detention without a warrant. Legal guardians, which I hadn't talked about earlier, but is covered under 573 as well. But more broadly, legally empowered persons include others within 4, not just law enforcement, but also emergency medical personnel. Elsewhere in the report, we urge that any EMTs that might be involved with various MCOTs or the like also have CIT training, but more broadly also including various medical professionals, physicians, nurse practitioners, other healthcare providers who are involved in working with folks with serious mental illness. Okay, so that's a nice list, number of legally empowered persons, but Shannon, so what? Well, the next piece is that a legally empowered person may initiate, and if safe to do so, transport the person to the mental health facility. Notice how that would broaden, if we were to adopt something like this, that would broaden the current authority, which permits only a peace officer to make that determination. And for this to work, if you have a broader array, those folks who are involved would obviously have to make some judgment calls of whether it's safe to do so and whether a peace officer should be called. We've already seen efforts in a number of communities with greater training for dispatch to make some initial assessment about, well, can non-law enforcement do the response? Can an MCOT that might not have a peace officer involved do the response? This would open the door for transport if there is a belief that the criteria are met where you wouldn't have to necessarily have a peace officer on the scene. Well, this isn't just pie in the sky, you know, oh, these medical school and law school academic types coming up. A number of states already permit this. For example, New York, not as broadly, but in addition to peace officers, they also give authority to EMTs. Ohio provides authority, for example, for individuals beyond just law enforcement. Several other states do that as well. For example, Tennessee permits physicians, psychologists, and other designated mental health professionals to escort. Florida permits physicians, PAs, psychologists, psychiatric nurses, others to initiate, in effect, and transport the person. What we also did in the recommendation is flesh out a little bit some of the traditional criteria, such as posing a danger to self or others, to be a little more explicit in identifying, well, what is it we're talking about? 1 and 2, we're talking about issues about serious types of dangerousness. That's not that unique, though, in terms of how dangerousness might be interpreted in other states. Also, in 3, 4, and 5, picking up some concepts of, like, somebody who is gravely disabled, as some states talk about, or deteriorating without some kind of intervention, can't take care of basic needs. 5, we had a lot of discussion on, but talked about how really trying to intervene where the person might not have the behavioral control to avoid criminal justice involvement, to try and intervene prior to that. Still, all 5 of those are consistent largely with a lot of traditional approaches. Where we went further is in subsection 2. And one Dr. Amador great yesterday. I want to build in part on what he was talking about because there's a connection here. One of the things our group talked about is many of the legal standards that we have in place today for civil commitment and emergency intervention were largely drafted in the 70s. And they were largely drafted tied to a dangerousness type theory and criterion. Some of that relates to some language in some Supreme Court cases that dicta was built upon. Some of it was because the state hospitals weren't particularly great places in the 60s and 70s, and there was concern about over-institutionalization at that time. But there hadn't been a lot of change in the basic criteria since that period. Yet think about what more we know about the brain today and what more we know about mental health. The studies that Dr. Amador was talking about in looking at anosognosia, I practiced that this morning. What Dr. Amador was talking about, the dates on most of those studies have been in the last 30 years. The research wasn't there in the 70s. We know more about the brain today than ever in human history. And we have the tools and the research ability to learn more. Well, if we know that 50% of persons with schizophrenia that's being untreated and over 40% of people with bipolar that's being untreated have anosognosia as one of the symptoms of those illnesses, do they have the capacity at that time to recognize the symptoms or appreciate the risks and benefits of treatment? I think, as we learned yesterday, in many of those cases, the answer is no. This would open the door as one additional criterion for legally empowered persons to get somebody to a mental health facility for an assessment as to whether mental health treatment is appropriate. We linked it back to the dangerous criterion, though, in terms of if there's not such intervention in the near future, is there a risk it's going to result in their meeting one or more of the criteria back up in one? In other words, the traditional dangerousness or inability to take care of basic needs criterion. Now, this morning, for purpose of this talk, I'm only looking at the emergency detention criteria, but I would add that with respect to the civil commitment standards for court-ordered treatment, whether outpatient or inpatient, we also recommend a capacity prong, a capacity criterion much like this. And again, some states have already taken that path. Judge Mack, when he spoke last year, talked about what Michigan's done. They adopted a capacity prong, a capacity criterion in 2018. Arizona has a lack of capacity language in their civil commitment statute, as do several other states. I think this is worth Texas giving a serious examination and look. In addition, a few other highlights that I'd like to note is the first bullet there, not much different from what we already have in Texas. An initiation with 4 hours of arrival and completed within 24 hours. Well, we have 12 and 24, but the 12 to be seen by a physician in that period. In addition, you see I've highlighted the word 5. Our committee had pretty extensive discussion on, well, what do we want to recommend as far as a period for emergency detention? And our group, including the 3 law professors and the other lawyers and judges in the group, believe that as a matter of due process, that 5 days did not offend due process. Texas, remember, 24, but I'm sorry, 48, but more than 48 if a weekend's in the middle. 43 states currently have 48 hours or more. We're part of that 43 state group. But 35 states allow 72 hours. Some states allow longer. I think, I'm going to check my notes so I don't misspeak. I believe it's Louisiana that has 15 days, New Mexico 10, and several states 7, and 7 or 8 states 120 hours or 5 days. So our recommendation for 5 days was based largely in part on a couple of premises. It wasn't just, well, we don't think it offends due process. Everybody's mindful that we don't want to have somebody held perhaps against their will for any extended period without the opportunity for judicial intervention. At the same time, though, the physicians, the psychiatrists in the group talked about how if you've got that extra period of time, and I don't even play a doc on TV, so I'm not somebody with clinical expertise in that role, but they told us that if they had a 5-day period, there was a much greater likelihood that the individual would be doing better and might not need further court intervention or further court-ordered interventions, or may make or be in a better position to make a decision to be a voluntary patient at that time. And you may have experienced this, particularly those who have been invited in against their will through an emergency detention, where it has been, say, on a Wednesday night, and you've got the longer period of the weekend to help begin treatment and work with that individual. Is there a greater likelihood of that person than voluntarily remaining? Or perhaps they don't need further intervention at all after that point. So that was an approach that we looked at as well and would urge Texas to take a look at as we try again to intervene. And typically my areas look at the criminal law side. Can we do more in this area on the civil side to intervene, perhaps at a slightly earlier stage, but perhaps with a criterion that allows us to recognize many of the people whom we're serving to avoid greater involvement in the criminal justice arena. So, you know, we law professors, we write articles. If you've got some spare time when you're flying home or all, I've got a link to an article I wrote this summer that basically focuses on the various recommendations in the model code report. The Florida International Law Review is going to publish it here soon, but the manuscript's available. But this is not an infomercial for my own article. I will admit it is not a critical look. I was part of the group, so am I going to criticize the group I was part of? Well, I could, but I didn't. It's more of an advocacy piece of why we ought to look seriously at these provisions and consider, are there aspects of it that might be of benefit to Texas and, more importantly, to Texans with serious mental illness who are in need of treatment and intervention. We've made great progress. We all know, or you wouldn't be here, more work's ahead of us, and I thank you for everything you do. You're on the cutting edge of really great things as we move forward, because as we heard yesterday, you care. You want the system to be better, but you want better outcomes for the people we serve. So with that, Judge Carr, it's yours.